Whether you need to submit the full 600 pages of the grievance investigation for the employment tribunal to consider very much depends on what's contained within that document and also what your claim is about. So whilst it's important to be efficient with the bundle and ensure you're only including relevant information, sometimes to exclude parts of documents can mean that the whole document is difficult for the tribunal to understand. So if you were to extract parts of that grievance investigation, would it impact on how that document looks? Will the other side agree? All of those sorts of things. So you've got quite a lot to consider as to whether or not you include that full 600 pages. And if you are set a bundle limit by the employment tribunal, then it would be a good idea to go through that and try to sift out the things that are relevant. Or alternatively, if you think, actually, if I start to pick this apart, it's not going to make sense in the whole for the tribunal when they're considering the case, then I would apply to the tribunal for an extension to the size of the bundle. Now, a 600-page grievance investigation report does seem quite long to me, but it does depend on the nature of the issue and the case. I do know some things are quite complex. So unfortunately, I can't give you a definitive answer in relation to this. I think it very much depends on what it is you're trying to convey with that evidence. And as I say, whether extracting some parts out of it is going to make the whole thing not make sense to the tribunal. So yeah, definitely look at it, see whether you need to include it. And if you do need to include it, apply to the tribunal to extend the length of the bundle.